record in 22-229, the preliminary hearing as it relates to the mother of the children, Ms. Noel Johnson. Welcome back, Mr. McFarland and Ms. Johnson.
Hi.
All right, Mr. McFarland.
Mr. McFarland representing Ms. Johnson. Need to have her introduced on the record.
We did that.
Okay. I don't know, I wasn't here. So.
Actually, Ms. Johnson, can you give?
Hi, my name is Noel Johnson, and I'm the mother of Jaleel Johnson Coleman.
Thank you. Deputy Ames, would you swear her in?
Raise your right hand, please. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. All right. Mr. McFarland, did you want to address some of the?
I do. I had an opportunity to speak to my client last Friday. I went over her rights. We wish to enter a plea of no contest. I'll elaborate the reasons why. She does not need to have a petition read. She was served, Your Honor. There are possible issues of criminality and allegations of domestic violence been sent to the prosecutor's office, drug use on my client's behalf, criminal parental neglect, possibly with the child being born with drugs in the system is the allegation, and not visiting in the hospital when the child needs help. So those are the issues, Your Honor, with potential criminality.
You just lost her. Oh, she's rejoined.
Here we are.
And I have gone over those issues which she would need assistance of in a case service. But we've discussed that also.
Great.
And also there is going to be an issue regarding the parenting time since the child is currently in Grand Rapids, Michigan. My client has no transportation.
Did you ask her if she has any Native American heritage?
I did. She does not, but father does have Native American heritage on his mother's side of the family. She's been informed.
Ms. Berger took care of that on behalf of her client this morning. They denied any Native American heritage.
Thank you.
All right, Ms. Johnson, did you hear the statements that your attorney made about you getting the petition and him going over some of the questions that we needed answered today?
Yes, I did. Yep, I've read it.
Do you agree with all the statements that he made?
Yes, I do.
All right, very well. I'm going to go ahead and proceed with the plea then, as long as Ms. Thomas agrees and Ms. Heiss thinks it's in the best interest of the children. Ms. Thomas.
I have no objection to it, Your Honor.
Ms. Heiss.
Yes, I agree that it's in the best interest of the child.
All right, Ms. Johnson, if I accept your no contest plea, I'm essentially looking at the allegations in the petition as accurate. You won't have to make any affirmative statements to that effect, but I will consider that the petition is accurate as far as defining what the issues are in the case. Understand that?
Yes, I do.
Very good. All right, if I accept your plea, you are giving up the right to a trial by judge or trial by jury, the right to have the petitioner prove the allegations in the petition by a preponderance of the evidence, the right to have witnesses against you appear and testify under oath at trial, the right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand you'll be giving up or waiving the rights I just indicated to you if you enter a no contest plea?
Yes, I do.
In regard to the consequences of your plea, or in other words, what will happen, the court will do the following. Third, there will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there is a problem that may be solved, the court can make the children temporary wards of the court, place them with a mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Ms. Johnson?
Yes, I do.
Do you have any questions about any of the information I've given you so far?
No, I do not.
Are you under the influence of drugs, alcohol, or anything else that can get in the way of you understanding what you're doing this morning?
No, not at all.
Is anyone making you admit to the petition by way of no contest plea?
No, they have not.
Has anyone threatened you in any way to get you to enter a no contest plea?
No.
You say your decision to enter a no contest plea is one you've made of your own free will?
Yes.
Thank you. The court accepts the reasoning behind the request for the no contest plea as being potential criminal liability. As to the factual basis of the plea, Ms. Thomas?
Thank you, Your Honor. If Ms. Grant can please be sworn to provide that factual basis.
You are cutting in and out just a little bit there, Ms. Thomas. I just want to give you a heads up. The volume's good. Go ahead, Mr. Deputy Ames.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, Ms. Thomas, whenever you're ready.
Good morning, Ms. Grant.
Good morning.
What is your role in this matter?
I have been the ongoing worker that has been assigned to work with the family.
And you are the one who drafted the petition that is in front of the court today?
I did.
And in your petition, as far as the allegations are concerned, how did you get that information?
Sure. So I was assigned, there was an investigation that took place. The case was confirmed for abuse and neglect and open to me in about mid-April from the investigator, Dawn. We had family team meetings, all of those allegations were discussed. Then we went forth and talked about like what needed to do to rectify that situation. Additionally, I am pretty familiar with Ms. Johnson and her entire family due to her previous children being removed from her care and placed in a guardianship.
For this child that's subject to the petition, was the child born with substances that came back positive, like in the umbilical cord?
Yes, this child was born positive with methamphetamine, amphetamine, THC, and morphine.
Was the child immediately released to the parents upon birth, or did the child need additional medical treatment?
No, the child was born premature. The child was born at 32 weeks, and due to that, he was actually transported to the Toledo NICU, where he stayed for about 6.5, 7 weeks. He was on a little air to help him breathe for a little while. However, that rectified itself pretty quickly. However, he remained on a feeding tube for quite a while. It was a struggle for him to gain and maintain weight.
Did the parents visit consistently?
They did not. For the most part, the entire time they were in the Toledo NICU, I believe the total amount of time that the parents visited of those days was about 8 to 10 times. And that was prior to our family team meeting, and they always visited on the weekends, super late at night, like 9 p.m., would only stay for an hour or two and then leave. After our FTM, they talked about how transportation and gas and money was an issue. We provided them with a $50 gas card. Punitive father's mother, Angela, had a vehicle at the time, and she was able to help transportation. However, even with the $50 gift card, they only went down, I want to say maybe 3 times after that before the child was discharged a couple weeks later.
And during your investigation, were there instances of reported domestic violence to law enforcement?
Yes, several. So the first was during the birth of the child. Hickman Hospital had some concerns regarding mom and dad's interactions in the ER, called in a welfare check for mom following that, and also alerted the Toledo NICU due to some domestic violence concerns. Following that, there have been a couple of times where police have had to respond to the couple's apartment where they reside with Josh's family for domestic violence incidents between the two of them. And then additionally, I learned after submitting this petition that the family actually was evicted from their house due to the amount of law enforcement coming to the home and domestic violence.
And the parents, were they also on probation for other criminal acts?
Yes, both are actively on probation right now. Through most of the case, they have had active warrants since mid to late April, despite several encouragements of me telling them to go and turn themselves in. They hadn't. They had other interactions with law enforcement that included the father picking up new charges when him and mom fled police when they tried to stop them, knowing they had warrants, and allegations of him breaking into a house where he was also charged with additional felonies. Then he was arrested last Monday, I believe. They were called once again to the apartment, which was the day they were to be out of the apartment, for a domestic altercation. There's no supplemental police report to that, but he was arrested then for the warrant he had.
As relates to the child, has the child had any medical conditions resulting from the exposure to substances in utero?
He does have a diagnosis of in utero drug exposure. The Toledo NICU was unable to correlate his premature with any substance abuse proceedings because of how premature he was born. However, documentations show that he has had tremors that are similar to drug exposed babies afterwards that go away on their own. He has a diagnosis, and I can't think of what the actual name is because it's very long and technical, but it's where his left eye is off-centered. That is going to require probably ophthalmology moving forward. There are concerns for developmental and neurological delays. The pediatrician has referred them for an assessment through early on to have early on complete a thorough assessment, and from there they will determine if he's going to need a specialist or not, or if it's something that can be easily corrected with early on interventions.
And since the child, Ms. Johnson did effectuate a valid power of attorney for her brother to have the child, is that correct?
She did. We did not know what her legal status would be when the child was discharged. She, at the time, was very wanting to do services and cooperative. We signed a power of attorney for her brother and his LTP to be able to care for the baby in case they were in and out of incarceration. Much as it stands right now, Noel does still continue to have the outstanding warrant, and neither have completed any services or requirements since the case opening in mid-April.
And has Ms. Johnson provided any financial support for the child or any necessary materials, diapers, formula, anything like that?
Very minimum to none. There was $30 that were cash apped when the placement asked for 40 because the can of formula costs $40 that he is on. They provided 30. They only provided maybe a pack of diapers and some clothes. She claims multiple times that she has things to give me, but that hasn't taken place. And when she has seen the child just the one time, that was all she provided.
All right. And then as it relates to parenting time, what is the current recommendation?
The current recommendation is for supervised parenting time. Due to the distance, we are asking for once a week and then also FaceTime visits. Noelle is actually very sporadically consistent with FaceTime, and the reason I say sporadically consistent is because it could be a couple of days, but then she'll follow it up with 3 or 4 actually calling and checking. My main concern with that is that some of those visits are less than 2 minutes. Most, if not almost all, are less than 5. She has only seen the child once in person, despite there's been 3 attempts to set up, rather there's transportation issues. She did attend 1 in person. However, I actually personally last Wednesday was willing to transport her to a visit and supervise for her. However, I had told her that she was going to need to confirm ahead of time, since it was going to be a drive to Lansing to meet the placement halfway. I had told her on Monday, we talked about it. We talked about it on Tuesday, even after hours at 6 or 7 o'clock, that, hey, you need to confirm with me by 9:30. We need to leave. I'm not going to have the child travel an hour and a half to meet if you don't confirm. She did not confirm in time, even with warnings in the morning to confirm to me, and did not reach out until about 10-15 minutes after the cutoff time to confirm was. So we're asking that it be supervised and then that she has to check in prior to that.
Okay. And about how much time prior to the scheduled visit time would the check-in need to be?
At least 2 hours would be ideal, especially with the transportation and how far it's gonna be. Whether that's her driving, the child driving, meeting halfway, the child coming to Adrian, whatever that circumstance looks like.
Okay, thank you. I have no further questions of Ms. Grant at this time. Thank you.
Ms. Grant, do you think that you could conduct an FTM to arrange a visitation plan with the parents before we come back for disposition?
Yes, the foster care worker can definitely work on that.
Thank you. Questions, Mr. McFarland?
You took one question away. That was going to be my suggestion also. I presume you're concerned with that delegation of parental rights that's only good for 6 months and mom could revoke it at any time. Is that your concern?
That is correct.
As far as the services mother might need would be, I presume would be a drug assessment and taking positive action towards that. Would that be true?
Yes, she's on probation right now where she's actually required to drug screen twice weekly. She's supposed to be in substance-based treatment to be compliant with her probation, the history of domestic violence, counseling, and just showing some stability.
And you said there's a warrant for arrest, correct?
Correct.
So I guess turning herself in would be another requirement.
I have actually asked her that since mid-April, and that was one reason why she didn't want to come in person today when I offered to pick her up.
We don't want her arrested en route to visit a child or anything of that nature, right?
Correct.
Okay, next, she's gonna need some assistance with housing. Is that something that can be provided?
So we have referred her, she has been involved with several programs, just never followed through with housing help, DHS assistance.
Well, we're talking about court ordered things in the case service plan that would be ordered that by both parties to head towards a positive housing situation. You believe that'd be positive, correct?
Yes,
She might need transportation help, parenting classes also, correct?
correct,
And we can discuss anything else at family team meeting that might be necessary.
correct.
And she can presumably start these services before we even come back to court for the disposition, which is her being ordered into these services, she can start, correct?
Correct, that's what the open case was trying to avoid, was coming here, yes.
I know even though she's local, she doesn't have good internet, as we see here. What's a good way for her to initiate contact with you to get started?
So she has my phone number, she's been, periodically, the problem is when you try to reach out to her, sometimes her phone is completely off. She doesn't charge it very often, it's dead quite a bit. Even when you're talking to her on the phone, it'll cut off and she'll say that she didn't charge her phone, so having that done. Since the family was evicted on 6/3, I have no updated address. She told me she would get me an updated address. I don't have one of those yet, but.
And do you have an email address for her?
I do.
Okay. Employment, assisting her with employment opportunities, that's also probably an issue we'll be discussing at family team meeting, correct?
Correct.
Okay, I can't think of anything further, Your Honor. Thank you.
Ms. Heiss?
No questions, thank you.
Very good. Any redirect?
No, Your Honor.
Thank you for your testimony, Ms. Grant. You may return to your seat. Anyone else you'd like us to hear from on the factual basis of the plea or some of the placement and visitation questions that were addressed?
No, Your Honor.
Mr. McFarland?
Well, my client, I can tell you what her concerns are, Your Honor. I don't know it's necessary that she testify. Her brother is in Grand Rapids. She's here local. I think the family team meeting, that's where everybody gets together to discuss. My client's still here.
Yes.
Okay, where the parties will sit together and discuss how visitations are going to work. Because my client would like to, she may have transportation up to Lansing, may be able to go to Grand Rapids, so how that can be equally shared. Also, she wants to participate in any doctor visits, consultations, if that be by Zoom or in person. She wants to be able to fully participate with that. The questions I asked regarding services are what she and I discussed, and she agrees that need to be addressed. I think a family team meeting where everybody gets together to kind of put this into writing is a good way to address the case service plan, which is that roadmap she'll be following for reunification with her and the child.
Good. Ms. Heiss, anything before I make the findings?
Your Honor, I don't know that a bond has been created between this child and his mother.
Okay, Ms. Johnson, you have to stop unmuting. It's interrupting our proceedings. You would be able to talk with your attorney and offer any testimony if you like, but we're trying to make a record where we can tell who's talking when, and we've got to cut down on interruptions. So please leave your device muted unless you are actively looking to contribute, which can be done by raising your Zoom hand or just letting me know, and we can try to make some time for that in a bit.
Okay, thank you.
I just think in working outside of the hearings, how can we balance the warrant with visits? I think she should take care of the warrant and then start the bond with the child. Now she's offering visits or maybe transportation to Lansing or Grand Rapids, but it's gonna be a conflict for even the placement to not have her face her warrants. So that would be one comment. Let me just check here. Yes, I think that addresses my concerns, Your Honor.
Would you like to respond to that, Mr. McFarland?
I'm not disagreeing that warrants have to be addressed, but with a newborn, I think they need the attention of a mother. If there's not a good bond, as frequent or more frequent, to form that bond. I don't know that by Zoom with a newborn, you can really form a bond. They can hear a voice. I think you're going to have in-person bonding. I don't know of any other way to do that. I don't know that we should hinge the outstanding warrant on denying her parenting time. I don't think that's an appropriate response, Judge. So we're going to ask for as frequent parenting time as possible in person. And I think that's what she believes, that there is a bond that has been formed. And I guess I will then ask her if she wishes to contribute. Right?
Very well. Did you wish to present anything on the removal question today? You have the option, obviously, to waive that if you wish, but if you wish to present testimony, that's also something I could consider.
Let me just question my client. I did ask her if she's okay with the placement, but we confirm that on the record.
Go ahead whenever you're ready. She has been sworn.
Can you hear me?
Yes, I can hear you.
How would you like me to address you today on the record?
With what exactly about the placement?
How do you want me to call you? What do you want me to call you?
You can call me Noel.
Okay, Noel. Are you okay with the placement with your brother in Grand Rapids?
Yes, I am. I'd rather him be with family than with a foster family. That he's not, that aren't related, that aren't relatives.
You've heard the concern of the worker and the guardian ad litem regarding you addressing your outstanding warrant, so you're not stopped en route, arrested from the child or anything like that. Your thoughts on that?
Yes, I do need to take care of my warrants. I agree that needs to be taken care of as soon as possible. I do agree.
The court would like to schedule a family team meeting where you and the worker and perhaps your brother would sit and discuss what transportation might look like, what the various services that we discussed and I placed on the record might look like for you. Are you willing to participate in that?
Yes, I am. Yes, definitely.
Can you do that in person here in Adrian? Since you're not coming through really good on Zoom?
Yeah, yes, I can. Yep. Yes, I can. I can participate in Adrian, whenever I need to. Yes.
Is that all you wish to contribute for today, knowing that you'll have that family team meeting coming up to add anything that you wish?
Yes, and also with his specifically his early on appointment coming up Wednesday. I know that one of them, Maddie and my brother had let me know that it takes place at their home. The only thing I would like to address is that all right if I go to if I am able to make it, is that a right for me? Do I have permission to go up to their home for that specifically and then go to the appointment after that at his pediatrician at 11:30? If I can say that so depending when the family team meeting is, in regards to turning myself in, I just want to be able to make that family team meeting in person and go to that early on appointment before I turn myself in.
Thank you. Nothing further, Your Honor. I guess I would call the worker when I have an opportunity, just ask her about that meeting.
And I was told by the worker, by Chelsea, that that was all up to the judge. I had actually called her previous to our court date this morning, and that's what I was told, that it needed to be addressed with the judge.
Thank you. Nothing further.
Do you agree with that, Ms. Grant?
I told her it would all depend on what her visitation would look like after today's hearing of what was decided.
Well, typically, participation with medical appointments is not considered part of visitation, and parents are encouraged to participate in that. So I would expect, unless you can show me a risk of harm associated with her participation, that she would be involved in that. Do you agree?
No, I've encouraged her to be a part of all of his pediatrician appointments, rather that's the place of calling, but again, if she can charge her phone or be available, that would be great.
Okay. Does that answer your question?
Well, I guess specifically, she would like to attend this at the brother's house where it's going to be held and then go to the doctor's appointment. Are you okay with that?
I would be okay with it. I'd want to double check with the placement. I know their big concern was, they've had some concern with her knowing their exact address just because of history and threats that were made against them. So
I suppose it could be done at a public library or a public place also, correct?
that is where supervised visits have been taking.
But I
place.
mean, this meeting,
I'm sure I know that early on here typically does it in a facility if needed, so I'm sure that can be arranged if needed.
But can I don't know.
Please don't interrupt, ma'am. You may have a chance, but you do realize that anybody can Google anybody's name and find
I mean,
it.
yes.
So it's not something that we can really hide.
I understand.
Nothing further.
Thank you. I would expect that the mother would be invited if there's obviously if there's a risk of harm associated with her attending any kind of medical appointments, then that would be an issue. But unless otherwise noted, which I have not really heard today, other than the warrant, if she gets arrested when she shows up there, then so be it. But hopefully that would happen outside the house, and we'll just ask everyone to be cognizant of that. But if she could, or if she can participate by Zoom, that might be a better choice. But I would expect her to be able to participate with that.
Thank you, Your Honor. Nothing further.
Ms. Thomas, anything before I make the findings?
Your Honor, I would, as relates to the early on assessment, I would ask, I think that it's maybe up to placement as to whether permit mother to be in person at their home without a professional there, as relates to the early on assessment. And typically, I know that early on can be in the community when they do their assessments, but typically they do home-based in the child's most natural environment to reduce any stresses that a child may have during the assessment. And so I would just ask us to be maybe a little cognizant of that and give the department a little discretion as relates to that particular appointment. But obviously we understand the other medical appointments that take place in facilities and the responsibility for the department to inform mom on that point. But with it, I have nothing else to add.
Ms. Tice?
I think it's all been addressed. I have nothing further.
Thank you. All right, yes, we can also give a nod to the fact that there is a power of attorney already in place, giving the placement the authority to make those decisions. So I do appreciate that perspective, Ms. Thomas. Thank you for reminding me of that. And I will leave it in the discretion of the placement as far as coordinating Ms. Johnson's participation in those therapeutic sessions. I know they can be regular and reoccurring, and we'll leave it to them to decide whether or not and how Ms. Johnson can be a part of that. As it relates to the plea, the child was put at risk as a result of mother's drug use while in utero. There's a period of hospitalization from 4 to 6 weeks. There are expected delays neurologically and physiologically. And yet I have no evidence that those issues have been remedied by either parent at this point. I do find that the evidence of the domestic violence in the home where both parents were residing also presents a risk of harm to the child. So the drug use, the criminality, all contribute to that. I also have acknowledged issues with transportation and now housing. I don't see either parent working at this time, so there are a number of areas posing a risk of harm to the children in the environment of both parents. So I do find there's been a violation of the statute as far as mom is concerned, and a risk of harm as far as placement with father. He appeared to us today from Lenawee County Jail, which certainly also supports the need for placement with the department. I do find the violation of section 1 has also been established. Technically, the language includes the parent or other person legally responsible for the care and maintenance of the child when able to do so, neglected or refused to provide proper and necessary support, education, medical, surgical, or other care necessary for the child's health or morals, and that the child's been subjected to a substantial risk of harm to the mental and physical well-being of the child for the same reasons I've already visited. So the removal is effective today. Placement with the brother is recognized formally and legally above that power of attorney, which I find is insufficient to provide the stability necessary for them to move forward, as well as use some of the funding that's going to be available through the department to help address some of the high-risk needs that this child is already exhibiting. The plea itself by Ms. Noel Johnson is found to be knowingly, understandably, and voluntarily made with a full understanding of the consequences. I will ask her to address that warrant before she exercises parenting time in person. So if she wishes to exercise that, continue to exercise that sporadic, regular parenting time as it was described, that's perfectly fine. Obviously, we'll give another nod to the placement on that to coordinate that and to allow that how they wish to, but until that's taken care of, I'm going to ask mom to just keep her visitations to virtual in the event that she gets arrested, frankly. I don't want to put this child through anything else, or the placement, frankly, or anybody else through that until that's been taken care of. Last, the department to conduct that FTM, hopefully Ms. Johnson will get her warrant taken care of very soon so that that can be effective in organizing visitation moving forward and her participation in her child's life. But I also acknowledge that Ms. Heiss is accurate. They described the situation that she's not able to or has not taken the opportunity to create a bond with her child as yet, given the circumstances as I understand them. And so we're essentially going to be building a bond with the child, and I would like to see her take care of some of the really high-risk things that could pose danger to the child during visitation, namely that warrant, also extensive drug use and potential domestic violence. I don't want to see any of those patterns present themselves for purposes of visitation. So I will ask you to jump into those services as soon as possible, especially that substance abuse assessment and services and that warrant, and then the department can work with you on putting together a visitation plan that will work for you. Ms. Heiss is in satisfaction of her obligations. Thank you so much.
Thank you.
As is our department for purposes of the statutes. Thank you. Child is in safe and least restrictive home with power of attorney and relative. That's it. Any questions?
Her disposition date.
Excellent question. How about July 1st at 1 o'clock? Okay.
Your Honor, are you showing MCI reviews starting at 1:30?
I am.
Okay.
I would anticipate, there's only 2 right now, and then 2 more at 2 o'clock. So I would anticipate all of those beginning at 2 o'clock to allow us enough time for the disposition of the pretrial in this case. Because I think we can take care of those. I think we need a full half an hour. Yes. All right. Any other questions?
No, Your Honor.
I think